This is case number 17CA011220, State of Ohio versus Jocquez Ross. Each side will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. The arguments are being recorded, so please keep your voice up and remain at the podium if you could. We've read the briefs and we are ready to proceed if you are.
Thank you, Your Honor. May it please the Court, I'm Jack Bradley. I represent Jocquez Ross. This is a death penalty case, and I am private counsel of Jocquez Ross in that case. I was representing Jocquez Ross in a pending drug case when he was indicted for this death penalty case, and he was indicted on January 20th of 2017, and we appeared for his arraignment on January 16th of 2017, and our first pretrial was on February 1st of 2017, and at that time the state of Ohio did not object to my representation of Mr. Ross. I had represented one of the decedents, Michael Lewis, previously, a number of years previously, but I don't believe that case was connected in any way with this case or would have had any impact upon my representation of Mr. Ross in this case.
Mr. Bradley, before you go on, do you want to reserve any time?
I'll reserve 5 minutes.
5 minutes, all right, thank you.
Basically, we had a second pretrial on March the 1st of 2017. Discovery had not been yet provided, but the state of Ohio indicated that they would get discovery to me. So finally on March 10th of 2017, I received discovery. We had a third pretrial on April 15th of 2017. The issue of my representation of Mr. Ross was not objected to by the state of Ohio. Our next pretrial was on May 10th of 2017. Again, no objection from the state of Ohio regarding my representation of Mr. Ross. Next pretrial was June 7th of 2017. Again, no objection from the state of Ohio regarding my representation of Mr. Ross. It wasn't until August 16th of 2017 that the state raised the issue of potential conflict of interest. At that time, my partner, Michael Stepanek, had been representing the decedent, Mr. Lewis, at the time of his death on an unrelated drug case, and it also appears that he had represented Michael Lewis's mother on an unrelated civil matter. We had a hearing on the motion to disqualify, and on October 3rd of 2017, the court ruled that I could not continue with my representation of Mr. Ross. On November 30th of 2017, Michael Stepanek and I dissolved our partnership, so he is no longer an attorney in my office or associated with me. I believe that no actual conflict has been demonstrated by the state of Ohio, nor is there a substantial risk that if I continue to represent Mr. Ross, that his rights would be limited by my representation. I don't think the state of Ohio has raised any issues other than that Mr. Lewis's mother had indicated to them that they did not want to see me represent Mr. Ross any longer because of my prior representation of Mr. Lewis. Again, this is a death penalty case. This is one of those rare occasions where Mr. Ross has private counsel. He has private counsel from someone who has represented him in the past, who he has faith in. I'm an experienced criminal defense attorney. I've been doing this for 41 years. I've done death penalty cases in the past, and it's just really unfair to Mr. Ross that after establishing a relationship with him, going through discovery, preparing for trial, there was a trial date set that had to be canceled because of the fact that my representation was terminated. It's just unfair to Mr. Ross that I can't continue to represent him, and I think that the state of Ohio has not met its burden, and I think that in this particular case, the court did abuse its discretion in indicating that I could not represent Mr. Ross in the future on this particular case, and therefore I'd ask that this court reverse that decision and permit Mr. Ross to have the counsel of his choosing in this very, very serious matter. Thank you very much.
Excuse me, was the court specific in finding a serious potential for conflict?
It was not specific, no, Your Honor.
Very good.
Thank you.
Any other questions? All right, thank you. And you have your full 5 minutes for rebuttal left.
Good morning, Your Honor. May it please the court. My name is Nick Bonamini and I represent the appellee, state of Ohio. Mr. Ross was indicted with 2 counts of aggravated murder with capital specification, among other counts. The victims of that aggravated murder were Michael and Fannie Lewis. So the state raised the issue of potential conflict of interest arising from Attorney Bradley's prior representation of Michael Lewis, one of the victims, on drug trafficking charges in 2009. His partner's prior representation of Michael Lewis on drug trafficking charges at the time of Michael Lewis's death. His partner's prior representation of Fannie Lewis in a criminal matter, and his partner's representation of Lorain Lewis, a potential witness in this case, and the mother of Michael Lewis. The trial court, after hearing the state's argument, disqualified Attorney Bradley because it specifically found that there was a serious potential conflict of interest that existed. The standard of review for disqualification of counsel prior to trial is abuse of discretion. Moreover, in reviewing the trial court's decision, an appellate court must be cognizant of the context in which the ruling is made and that the likelihood and dimension of Natson conflicts of interest are notoriously hard to predict. Here, the appellant had a presumptive right to employ his own counsel. However, that presumptive right could be overcome by a serious potential for conflict. In Gonzalez-Lopez, the Supreme Court said that a defendant may not demand that a court honor his waiver of conflict-free representation. In other words, the Supreme Court found that a defendant does not have an absolute right to be represented by an attorney with a conflict of interest. Here, the trial court did find that there was a serious potential for conflict. An appellant has not shown, and nothing in the record suggests that the trial court's decision was unreasonable, arbitrary, or unconscionable, as would be necessary under an abuse of discretion standard. Rather, the record reflects that the trial court considered the facts of this case. The trial court considered that the appellant was charged with aggravated murder of Michael and Fannie Lewis. The trial court, in its entry, considered that Attorney Bradley had previously represented Michael Lewis in a drug case, and at the time of Michael Lewis's death, Attorney Stepanek, Attorney Bradley's partner, was actively representing Michael Lewis and had been for 2 years in a pending trafficking and drugs case. Moreover, the trial court was aware that the state believed that this murder case was drug involved, and that the motive in this case was drug involved. So the trial court considered that. The trial court also considered that Attorney Bradley's partner had previously represented Fannie Lewis in a criminal matter, and that he was using Michael Lewis's, one of the victim's retainer money, to represent the victim's mother, Lorain Lewis, who was a potential witness in this case. The trial court didn't have the benefit, the Supreme Court's found that the likelihood and dimensions of nascent conflicts of interest are notoriously hard to predict. That's what the trial court had to do here. It had to predict the likelihood and dimensions of future conflicts of interest arising during trial from Attorney Bradley's prior representation of the deceased victims and a potential witness. I submit to you that there's nothing to suggest that the trial court abused its discretion in predicting that there was a high likelihood, that there was a serious potential for conflict. I submit to you that The appellant has failed to show that here, and I ask that you deny appellant's assignment of error and affirm the trial court's ruling. If there are no questions, I'll see the rest of my time.
What about the fact that there was such a delay in raising the issue and no objection at the multiple hearings?
I think if you look at the actual period of time, there was a few months, but the state represented in its hearing before the trial court judge, because this issue was raised at the hearing on the state's motion. The state represented to the trial court that it previously hadn't been aware of the extent of Attorney Bradley and Attorney Stepanik's prior representation of the entire Lewis family, and that is why it hadn't raised it earlier. It also became aware that Attorney Stepanik himself represented that he was uncomfortable by, he had appeared at a number of pre-trials in this case, Attorney Bradley's partner, and he had represented to the state that he was uncomfortable by his representation of the appellant, and that the state also became aware that the potential witness, Loretta Lewis, expressed that she was uncomfortable with Attorney Stepanik, Attorney Bradley's partner's representation of the appellant.
Was there something more than just the mere fact that Attorneys Bradley and Stepanik represented the victim's family? I mean, was part of the evidence in this case statements that Lewis's may have made to either attorney that created a potential conflict?
There's nothing in the record regarding specific statements that the Lewises may have made to either attorney. But the record does reflect that Attorney Bradley's family were representing Michael Lewis at the time of his death on a drug trafficking case, and that the state believed that the motive behind his murder at that time was drug trafficking or was drug related. So the trial court was faced with the prospect of, before trial, before this developed, deciding whether there's a serious potential for conflict. And that's one of the things that had to consider, whether information conveyed, specific statements conveyed by Michael Lewis would become, to his attorneys, would become crucial or relevant at trial.
Is the test a risk, or is the test a substantial risk of conflict?
The test is a serious potential.
Serious potential.
And the trial court did find a serious potential.
Any other questions? All right, I don't see any other questions, so thank you. You got a full 5 minutes, Mr. Brennan.
I think if we look at the Ohio Rules of Professional Conduct, Rule 1.7A2, it does talk about a substantial risk in the ability of the attorney to consider, recommend, or carry out appropriate course of action for the client, and that his ability will be materially limited in his responsibilities because of the representation of the former client.
Did the court consider 1.9? That's why I was asking. The duty an attorney has to a former client not to disclose information obtained during that representation.
Not that I'm aware of, Your Honor. But the thing is that, again, this is not one of those cases where a former client of mine is going to get on the witness stand and testify, and then I use information that I had gained from him previously in a drug case to try to impeach him. The state has some theory, but certainly not a theory that is unknown to them. Pardon?
How about the mother? Was she a witness?
As far as I know, if she's a witness, she's not a witness to any of the facts in this case, because this murder was committed in a parking lot. No witnesses were present. There was one witness who saw someone running away from the car that Mr. Lewis and Fannie Lewis were in. They were assassinated, basically, shot in the back of the head, and Mr. Ross was linked to this particular crime through his cell phone, and that his cell phone allegedly was in the area where this particular crime was committed. Mr. Lewis, yes, was under indictment for drug charges. Mr. Ross was under indictment for drug charges. But I don't think there's going to be any secret that the state is alleging that Mr. Lewis was involved in drug activities and that Mr. Ross was involved in drug activities. I mean, that's the state's evidence. It's not going to be something that I'm going to bring out and say that Michael Lewis was a drug dealer and therefore many people could have had a motive to kill him. The state of Ohio is going to bring that evidence out because they want to link my client, Mr. Ross, with Mr. Lewis through drug activities. So,
But counsel, in representing Mr. Lewis, you might have more knowledge of how that drug business was run.
well, that was in 2009 that I represented him. The case that was pending, he was never convicted of. And so that's information that the Elyria police certainly have knowledge of. They were the ones that were pursuing the charges against him. The state of Ohio prosecuted Mr. Lewis in the past. They convicted him in the past. And if the standard is that if Jack Bradley had represented somebody in the past, then he can't represent somebody in the future, then my ability to represent clients in Lorain County is going to be strictly limited because I've been doing it, again, 41 years. I've represented a lot of families in Lorain County. I do it only as private counsel, and I don't think that people that want to hire me as an attorney should be limited because I've represented someone who's a victim years previously. Unless the state of Ohio can state something specifically that shows that there is a substantial risk that my ability to represent my client is diminished. Mr. Ross wants me. He indicated to Judge Rothgary that he wanted me to continue to represent him, and I think that in a death penalty case, he should have that right.
Go ahead. No, I was wondering about your associate, though, in regard to the representation of Mr. Lewis.
Well, that was a pending case. He's no longer my partner. He's not going to be involved in this particular case. So,
but he was
at the time, yes. But there was nothing specific as to what he was representing Mr. Lewis for and any connection between that representation and Mr. Ross's pending case.
I think Judge Callahan has a question.
Counsel, were you to remain on this case and were it not to be a successful defense and your client was facing either conviction or conviction with the death penalty, after sufficiency, manifest weight, and constitutional challenge to the death penalty, what do you think the next assignment of error from the state public defender's office is going to be?
Either way, it's going to be raised.
Either
way, it's going to be raised.
Yeah,
so,
you're right about that.
So, you know, we've addressed that issue. Mr. Ross has addressed that issue in front of Judge Rothgary, and he's told Judge Rothgary that he wants me to represent him. So, obviously, if I'm not representing him, and either new counsel has to come in or he has to have appointed counsel to represent him, that issue is going to be raised. So we know in death penalty cases, every stone is turned over, and we know that assignment of error in the case, no matter who the counsel is going to be ineffective assistance to counsel. So,
Well, I'm not talking ineffective, I'm talking conflict.
well,
You're right, ineffective is going to be there also. I guess I should have made that number 4.
right.
And I'll let you answer this question. After that, he's out of time.
Well,
Go ahead and answer
the issue is, you know, I will represent him with competent representation. I have the experience. I've been there before, and Mr. Ross has clearly indicated to the court that I'm the counsel that he wants. I was representing him in a pending case. It's not like I just developed a relationship with Mr. Ross. And then the other issue is, how long can the state wait?
I think you're past my question answer. Thank you.
Thank you both for your presentations and arguments. That's okay. The court will take the matter under advisement, issue a decision in due course. Of course, the clerk of courts will mail you a copy of the decision the day it's released, and the opinions are also posted on the Supreme Court of Ohio's website. So we appreciate the arguments. Thank you.
Thank you very much.